Hi, my name is Andrew Kinney. I'm an attorney at Hoagland Law Offices. I've been practicing in the area of Social Security disability law for now over 20 years. This is a series of videos like a classroom to explain Social Security from the ground up. The Social Security disability process includes supplemental security income. What we have here is the 201 section. This is moving forward to the next level of Social Security discussion. We have a series of videos that should be available for Social Security 101 going through some of the basic concepts or important things you need to know, especially if you or someone you love is going through the process, and it is a process. So for Social Security Disability 201, this will be a series of classes with a little more depth. We're going to go through an overview of what a typical case would be like in a little more detail. In previous discussions, we learned with Social Security disability law that unless there's some exceptions in a few states, we have an application level, reconsideration level, then a hearing level, then appeals council level. There are 4 levels of Social Security. Each level, if there's a denial, there's an appeal period, which is 60 days to get to the next level. If you don't do that, you need good cause or you need to start over. So keep in mind that a typical case is that someone's denied twice and then gets to a hearing and can be approved for benefits. So a typical case when someone comes to our law offices is that they haven't applied yet. We help them apply. And when they've applied, we help them apply either online or some other means. Once we get the case started, again as an overview, we're analyzing on the front end whether there's sufficient medical evidence to support disability. Anyone can say they're disabled, and we see a lot in the media about people that really may or may not be disabled, but when push comes to shove, Social Security disability law requires medical evidence, objective medical evidence. So if there's a physical problem with someone's back, it's an MRI that would be required to establish disability, not just someone saying they have a bad back. There's a lot more to it than the media would think. So with Social Security disability law, here's an overview. So we'll take an example. I'll make up a name, John. John comes to our office having called us first, and when we were screening to see if he had a good case, this person, John, let's say he has low back problems, construction worker, he's 52. He's unable to work now. What we'll typically see in low back problems is that someone will have pain not just in their lower back, but there can be pinching of a disc and have one or both legs that are also involved, and there's chronic pain. It's just an irritating backache that goes away. It's chronic, and it causes sensory loss or numbness. If someone calls and has problems like that, we'll take them in at the application. They may have applied already, but in any event, a typical case is that they're coming in the door. There's 4 to 6 months for someone named John, right, this person, to be evaluated. Now, it's usual at the first 2 levels, the state agency levels, application and reconsideration in most states where that exists, that they'll be denied. The state agency will recognize that being over 50, in this example for this John client, being over 50 and sedentary restrictions under the law would allow them to be approved. That's called the medical vocational guidelines. It's typical that we'll see them considered to be light, or they can do exertional levels beyond sedentary. They can lift up to 20 pounds, or they can be on their feet up to 6 out of 8 hours in a day. We'll usually see at the first level and then the reconsideration level, evaluators somehow seeing that they can do light work when they know that sedentary would allow an approval. So the first 2 stages, 4 to 6 months roughly for each stage, slightly shorter at the reconsideration stage. This overview here will now go get John to a hearing. It can take, depending on where you live, about a year to get to a hearing. With this fact pattern with this John, what we'll see is that typically by the time they get to a hearing, they would have been waiting maybe about 2 years total, and at the hearing level they may have already had a back surgery. So hopefully with this client they would have had a back surgery and gotten better, and then there was at least a year where they were unable to work their past work the way the laws apply at his age level. So in considering Social Security disability, we look at age, we look at what is objectively wrong with someone, but we also ask, are there subjective problems? How does chronic pain affect your ability to concentrate? It's not enough for Social Security system to just know that someone's complaining of depression. They actually have to have it diagnosed and treated and evaluated. So it's a misunderstanding that one can say they have problems and that's all they need to do. They need to show actually with a psychologist or a mental health professional they need to show the problems in a way that they can confirm that, for instance, there's chronic pain syndrome or depression. At a hearing for this client, John, what would happen is that this client may have had a surgery, and the question then is, did the surgery work? If it's within a few months after surgery, it might be too tough to tell. What is also usual is that after surgery, it's tough for us as a law firm to get feedback from the surgeon, although there are exceptions. But surgeons can tend to be optimistic about their work. The surgical scar is healed, and there may be less pain. But in the end, what Social Security is looking for is objective examinations for this client at the hearing. One of us, we have a number of attorneys at our firm, we would go to the hearing with a federal judge into the private conference room, and I would explain why John, despite having surgery, has not recovered enough to be able to be on his feet 6 out of 8 hours in a day and lift up to 20 pounds 2 hours a day occasionally. It's a rough estimate. So here's an overview. If John was denied, he'd go to appeals counsel. And the way appeals counsel is structured is they broaden the scope of appeals counsel, but over the years I've noticed, and it's a very particular problem, appeals counsel has made very poor efforts at being technologically savvy. They can be. It's hard to even change an address with them. They have old-fashioned faxes, which one person I know made light of from there. So we have a broken appeals counsel system. It's hard for me to know if it's by design, but the result is it's by design. Not a very good option. In fact, it's a failed process or system. This person, John, hopefully wins at a hearing. A majority of people do, because evidence is looked at fairly. At the appeals counsel, there may be some technical errors to send it back to a judge, and I appreciate when there are errors that are found. But with one attorney analyst looking at a case at the appeals counsel after about a year of waiting, again, it's fairly irregular when the truth comes out. So here's the overview of Social Security 201. If you have more questions, you can call our office at the number at the bottom of the screen. Thank you.